Let's welcome my good friend, attorney at law, Mr. Martin George. Good morning, sir, and a happy Christmas to you.
Yes, hi. Good morning to you, Brother B, and all the best to you and all the viewers of Tobago Channel 5. I understand that in Maldives, in Bora Bora, in French Polynesian Islands, they all tune into you. All
Yes,
over the world, they tune into Tobago Channel 5. So
yes,
we
yes.
wish all of them a Merry Christmas all around the world.
All right, Mr. George, I don't know where to start with you, but first of all, let's stay. We're coming to, obviously, the opening of the beaches and so on. First of all, let's go to, and I want to get your view on the response from the Chief Secretary, newly installed, to the Attorney General. You are being an exponent of the law, should we say. Let's
Yeah.
speak from that standpoint, and what was he out of place? And was the response an accommodating one? Give us a view as to that scenario, that
Okay, so
situation.
Brother B, as always, I like to have recourse to the law to guide us. And when one considers the judgment of the Honorable Justice Nadia Kangaloo in the matter of Tobago House of Assembly versus Attorney General, which was a matter which was decided a few years back, and in which she gave her ruling, it is clear that we have to consider how one treats with this in terms of the relationship between the THA and the not just the office of the Attorney General, but the central government generally. And in that judgment, which she indicated, she delivered it on 10th June 2015. And she indicated quite clearly that because of the provisions of Section 75 of the Constitution of Trinidad and Tobago, regardless of the several areas of responsibility which are set out under the fifth schedule of the Tobago House of Assembly Act, it is clear that no policy of the THA can be in contravention with overall national policy on any issue. That's the ruling of the court. So we have to understand this is the current interpretation of the law. So, in other words, the THA, and I mean, I know this matter inside out, Brother B, because I was part of it. I was part of the team, right? And we examined everything in this. We examined the history and genesis of the previous THA Act when it was laid in Hansard. We got all the readings, all the submissions, all the contributions. Then we got the amended act, the 1996 THA Act. We examined that. We examined how they were, discussing it and what were the intentions behind the legislation and the changes that they were making. And after all the legal submissions, the court ruled that in those circumstances, Section 75 of the Constitution, which creates the Cabinet for Trinidad and Tobago, puts the cabinet in that position of paramountcy over all of Trinidad and Tobago. And as you would know, Brother B, the cabinet comprises, firstly and foremost, the Prime Minister and the Attorney General. So while in one sense it may be a good sound bite to sound as if you're standing your ground and you're standing up for the people of Tobago to say, well, you're not answerable to the AG. So in that sense, one can understand, the point that Mr. Augustine was trying to make. The reality is that under the current state of the law and the legislation, according to the judgment of Justice Kangaloo in this matter of THA versus Attorney General, it is clear that the cabinet does have supremacy and paramountcy over all of Trinidad and Tobago,
All right.
including the THA. And
Okay.
this matter was brought by the THA.
All right, let's deal with the bone of contention. The focus here is not necessarily the THA, but Watson Duke and the PSC. Let's separate that a little bit, and then we'll come to the appointment of him being Deputy Chief Secretary. And of course, the law says that cannot be accommodated because you can't have both. Let me ask you in this instance where Watson has to choose. Uh, hmm, he commands a more prominent position as a union leader of the PSA. He can speak to the government how he wish. He does have that flexibility. He does have that clout. If he becomes and abandons the position of union leader of the PSA and becomes just the deputy chief secretary, that power or that clout that he can, flex his muscles, as it were, will be minuscule in that he will not have the national attention, so to speak. Just weigh the two for me from a common sense approach and from a legal standpoint. Give us your view, sir.
Well, I mean, obviously, one understands that if you are leading the PSA, your body politic, so to speak, is a larger mass than the number of, say, PDP supporters you would have in Tobago. So therefore, in that sense, one can understand the attraction of the larger slice of the pie, so to speak, in that regard. And of course, as you say, you have greater clout nationally, you have greater control and power. So, of course, at the end of the day, it's a matter for Mr. Duke to choose, well, okay, which do I want to serve? Because, I mean, the Bible told us years ago, you cannot serve two masters, right? And even if you try to do so, you can't do it adequately. One will suffer for the other. So I think that is where Mr. Duke is impaled on the horns of a dilemma here. In other words, does he choose to say, well, hey, listen, do I devote myself full time to Tobago in the role of Deputy Chief Secretary, or do I give that up and say, look, let me focus on my union duties and my union responsibilities? Now, of course, the fact that he's already been appointed Deputy Chief Secretary, I think there would be a certain expectation from the people of Tobago that he would be there to serve their needs. So in that way, he's been painted into a corner in a bit. However, if it is that he is able to come up with some credible explanation to show that, look, there's a greater national calling for him in terms of serving as PSA president, then, of course, I guess he may then have to relinquish the role of Deputy Chief Secretary, because even as Deputy Chief Secretary, you are still a secretary of the Assembly.
Right.
That has to be clearly understood.
Yeah.
You are a secretary, so therefore there would be that conflict in terms of the holding of two substantive portfolios.
Very good.
And,
all right.
There may be some, merit in the argument to say that, even if you are not receiving a salary, the fact of the matter is there may be perquisites or benefits or, the trappings of office and the influence that can be wielded may create some sort of a dilemma and a dichotomy in terms of your dual functioning in both roles. So I'm not sure that it is really something that is possible to argue legally to say that, look, yes, I ought to be entitled to continue in both roles regardless, if you understand me.
Yes,
and
yes.
I'm fairly confident that Mr. Duke will have to make a choice one way or the other,
Very good.
regardless of the outcome of the legal matter.
All right, so let's go now to the Prime Minister's announcements. You have been clamoring for beaches to be opened. Of course, we have a few hours between 5 and 12 thereabout. Are you satisfied that that's, or are you happy with that response? Or that, and do you think that it's supposed to be open generally?
Well, the fact is, Brother B, listen, we have to be practical and realistic. This COVID-19 pandemic is a moving target. No one person, no one country, no one leader has all the answers.
Excellent.
So basically, we have to take baby steps. So if this is a start, we are grateful for it, and we are not going to rail against it and say, well, it should be more. If you understand me.
Excellent.
I mean, at the end of the day, we have to be reasonable and practical. And if it is that we can find a way to make this work as a start, he did say he's willing to consider opening it wider. So therefore, in those circumstances, we are urging the public to be responsible, respect the rules, respect the guidelines, ensure that we, comply with them, and then maybe we can see how that works, and then of course the government will then consider maybe expanding
Opening.
it more.
All right.
But for now, we are definitely grateful for this because it's going to mean a return of visitors to the island. Because I'll tell you, Brother B, the lack of beaches is one of the biggest
Yes.
drawbacks and
Yes.
hindrances for people coming to Tobago. If you
Excellent.
come to
You're
Tobago and you
absolutely
can't
right.
go to the beach,
Yeah.
what's the point?
All
You
right.
know?
So what we'll do, we go for a break. When we come back, we talk mandatory vaccination as well as Minister for workers in January 2022. See you after the break, Mr. George.
Yeah.
All right, welcome back, and we continue our conversation with attorney at law. We're speaking to him as an attorney this morning, and a great contributor, a brilliant mind in Tobago. We are listen. Let me tell you, we look forward to your comments on Facebook. And when you make your comments, always to the point, direct. And we really appreciate you, sir, and appreciate you when we call on you and you're always available. Thank you for that, sir. Yeah.
Yeah, no, you see, Brother B, I see this as part of our contribution, both you and myself, towards nation building. Because, in Trinidad and Tobago, of course, we all love a good lime and old talk and the Picong and Moviland. But there are times when you need to elevate the level of discourse to serious issues and to have mature, sober, rational discussions. And that's why I always like to put things in a historical context, to quote examples of things that have occurred before to show people, and also to quote the law and the legislation and the cases to show that, look, there is guidance legally that we can use to
Okay.
find solutions to things.
All right, let's go now. Legally, and the Attorney General spoke as to the legal approach to this mandatory vaccination for government workers. Let's talk that. What the Attorney General outlined, and he was very cautious as he navigated his way through explaining to the public from a legal standpoint this mandatory vaccination for government workers. Walk us through.
All right, okay. So, Brother B, let's unpack this because there are arguments on both sides. Okay, now I think you guys played a clip from the president
Yes.
of the Industrial Court,
Yes.
Her Honor Deborah Thomas Felix, who made her position very clear, and that was since February this year at a webinar where she made it clear that as far as she's concerned, no employer could unilaterally change the terms and conditions of employment to make the COVID-19 vaccination mandatory for employees. Right? Now, the interesting aspect of that is that one would hope that for any of these cases reaching the industrial court, that she would immediately recuse herself because she has clearly shown what her predisposition is on the issue.
Okay.
All right. So that's something to consider. All right. However, the industrial court has also said in the matter of Communication Workers Union versus National Training Agency, in that matter, the industrial court has said, and this is a case that was decided some time ago, they said, terms of employment cannot be changed or altered unilaterally in keeping with the principle of good industrial relations practices. To alter or change such a term requires discussions between the employer and the worker where there is no recognized majority union, eventuating in an agreement thereon before implementation. So what they said in that case, basically, the industrial court basically said, listen, you can't do this unilaterally. You ought to have discussions with the employer, with the employee, and the recognized bargaining union, and before making such a decision. And basically they're saying it should be something that must be mutually agreed before implementation. So this is looking at it from the industrial relations context and the contract law perspective. So one understands that. However, Brother B, if it is that it is necessary to implement such a thing and you bring legislation to this effect, then that trumps everything. And I always like to refer to the historical context of the United Kingdom. If you recall, in 1796, when they invented the smallpox vaccine, there was much opposition worldwide and also in the UK to the vaccine. There were anti-vaxxers, there were vaccine hesitant people, and there were anti-vaccination leagues which were formed where masses of people, they protested against the vaccine. We're talking centuries ago. So this anti-vaccination sentiment is not anything new. We've seen it worldwide before. However, the United Kingdom in 1853 decided, listen, this is nonsense. It can't go on because too many of our people are dying. And well, I think the Prime Minister echoed similar sentiments. And they instituted mandatory smallpox vaccination by the Vaccination Act of 1853 in the United Kingdom. I invite your listeners and viewers to research it, look it up. Look up the 1853 Mandatory Vaccination Act in the UK, and they made it mandatory that everybody must get the smallpox vaccination, and that is how they were able to stop the spread of that dreaded disease that was killing millions of people. So, as I say, legislation will trump the contract law position and the position in the industrial court where they are saying, look, you must engage in this type of discussion and negotiation with a worker.
Okay.
So I think that's where the Attorney General is basically pitching his argument for this change.
From a public health ordinance standpoint, he has also brought that to bear in the conversation. So let's say that and going back to the point you made, that no company or no place of employment can unilaterally just decide, look, we are going to impose this. There must be. So let's say that an employee, for whatever medical reason, he or she is not able to take the vaccine. There has to be an accommodation there and factor in the Public Health Ordinance Act that gives the government the, should we say, the go-ahead to impose this. Take it from there.
Right. So therefore, yes, clearly you must have exemptions for persons who have valid certified reasons for not being able to take the vaccine. So the two main grounds are religious grounds and medical grounds. So, of course, I would imagine that any legislation that they're looking to bring will obviously contain those provisions that allow for persons to apply for and to be granted those exemptions. However, there must be valid cases. They cannot be spurious or artificial or manufactured or concocted cases. You saw I think it was the UK where some guy went for his vaccination with a fake arm. I mean, he created a plastic mold over his arm.
Yeah.
I mean, that kind of thing is ridiculous. So it has to be a genuine case for you to apply for and to be granted the exemption.
Right.
However, Brother B, let us not forget, and I always like to remind Trinidadians and Tobagonians of this, let's not forget our history and the fact that we already have on our books legislation for mandatory vaccination. That's Section 5 of the Public Health, Nursery Schools and Primary Schools.
Very good. Right. Yes.
Chapter 2803. Right. Under that act, you must be vaccinated as a child in order to attend a public primary school in Trinidad and Tobago.
Does that apply?
I've been through it, Brother B.
Yes,
you
but
got your vaccination.
So,
I got mine.
all right. So government is on that basis has the all clear to impose that based on what you just explained.
But it's what I'm telling you. So we need to understand and not conflate the two positions. Remember, you have your contract law position, and that's what the industrial court is speaking to. They're speaking to the contract law position and the position under the Industrial Relations Act and the principles of good industrial relations. That's fine. So in other words, if it was simply a contract law issue, then sure, what they are saying is correct. However, if you bring legislation, the legislation overrides and trumps that.
All right. Okay.
And the legislation is what will make it mandatory.
All right. So if there's pushback, government could say, look, let's do this from a legislative standpoint, and there's
That's
nothing.
the point.
Right.
In other
And
words,
there's nothing no one can
you
do.
legislate to vaccinate.
Right. All right. So, but do you see this as I mean, you've advocated for it before, so this would be a question really that doesn't have any value. But I want you to bring it and how necessary this is for those who are waiting to push back, as it were, those who are waiting to hit the road or to protest against this needed approach to bring us to some level of normalcy. The stats have shown that the unvaccinated are the ones who are dying and getting sick. Bring that into perspective as to where we need to go as a population, and if we are serious, is the only way, is it?
But if you look at our numbers are still low. Our vaccination numbers are low. That's the reality. And I mean, I saw an analysis on the weekend which showed that for this past week, there were less than 700 new persons per day being vaccinated throughout all of Trinidad and Tobago. That is ridiculously low given the large numbers of unvaccinated people. You saw the statistics the Prime Minister gave in terms of the low numbers of vaccination uptake in the armed
Protective
services, the
services.
army,
Yeah.
the police, the fire services, even among nurses. And he spoke about healthcare professionals in Tobago, and he said it was hovering around 50%. So therefore, given that, it may be necessary sometimes, Brother B, to take the bull by the horns and take what may be tough, decisive positions, even though you recognize that there would be pushback. And that's what occurred in the UK, and that's why I like to put things in context. People, if we don't study our history and understand where we came from, we will never know where we are going. So therefore, we need to recognize that this is not something novel or something that is, impossible. And as I made reference to the Public Health Immunization Act, which is on our laws in Chapter 2803 of the laws of Trinidad and Tobago, I invite your readers, go look it up. It is there on the books already. We already have mandatory vaccination laws in Trinidad and Tobago.
Okay. All right. So on that basis, we expect your colleague, the Attorney General, to push as much as he can to ensure that 2022 vaccination mandatory for government workers. All right. And in closing, we're getting ready to wrap. So, all right.
And sorry, Brother B, just to mention, you recall that we were the ones who actually told the Prime Minister several months ago that by January he ought to make a decision. So we are quite happy to see that he has made a decision and has set January as the timeline.
Very good. All right, so let me extend, best wishes to you and your family. Of course, no Christmas lime and so on. But hey, Grover here, Grover here,
Yes.
Grover here.
Yes. No, we can't have any. Lots of people
Yeah, I
have
know.
been calling me, but we can't have any lime.
All right, but anyway,
I mean,
all right.
we'll still make it a good Christmas.
All right, just to send best wishes to all of your followers on Facebook and people who listen to you on a daily basis and the general public. Best wishes to you and your family.
Thanks very much. And same to you and all the staff at Tobago Channel 5.
Very good. Thank you, sir. All right. And of course, Martin George there, Mr. Martin George, attorney at law. And he spoke to us about the government does have the will, the law, the law is backing this move. And so we are hoping that it runs smoothly. And this would be January 2022. And that is next month earlier. And so mandatory vaccination for government workers. All right, let me say good morning to all our viewers. Me and Jean, Dan Binskin, Shirley Cook, Miss James, and many others who are on Facebook. First time saying good morning to you, and of course, thank you all for choosing us. For those of you on Pulse 89.5 FM, we are indeed thankful that you chose us. Let's go for the break. When we come back, lots more.